Okay, so they appointed the Curran solely on the basis of your failure to comply with management system directions, which were apparently issued by someone who was not even legitimately appointed,
and the second auditor as well,
who was basically appointed because you
was appointed by Alice Duggan as well as a follow-up.
So same issue, but also I've seen some of the documentation for that, and the basis for that was that you hadn't complied with the management system directions of the first auditor.
That's correct.
So effectively everything is about nail-on determining that because of your Asperger's syndrome, you're essentially incapable of carrying out the work of lawyers.
And that led to him taking me aside and saying, I recommend that you have me come in and assist you managing your practice for an exorbitant fee per week. And to which I said, I've managed my practice for many, many years, since November 2002 to now, 2021.
So he elicited a bribe from you, effectively.
Basically, yes.
And he made it clear that if you...
And I responded in my response to his report.
So you made that allegation to the commissioner?
Yeah. He didn't like that. They didn't like that. They wanted to have someone as a spy in.
So did they investigate that complaint?
No.
And again, he wasn't offering medical treatment for us.
So the response to that was, you need to do management system directives now. That was the penalty for that.
He wasn't offering medical services for your Asperger's. He was...
No.
Okay. I was just
For
confirming.
thousands of dollars a month to as an expense to my practice.
It's like protection money.
Well, basically. You either do this, otherwise we'll find a reason to hurt you back.
Okay.
And keep you under investigation.
And because of that, they appointed a Curran, who then charged your practice $200,000, refused to take the money that your clients were willing to
Refused to continue with court cases where I was suing people for
and
recovery.
the money that they were trying to pay for services already rendered.
And also the sale of my wills and deeds to Lillian Di Maria and Doreen and Associates, which is on her website.
So they wouldn't send it to...
I don't even know what they received for that. Not does my liquidator know what they received for that.
How's that possible?
Don't know, that's possible. He's never seen this in his life from G.S. Andrews accountants, chartered accountants.
So...
He just cannot wind the...
So it was the property of your company, and
yes.
Your company has never been told at what price it's been sold off?
No. The files, where they've gone, and basically it took 6 months for me to go back into the premises because I had to deal with the landlord. They thought they'd lumber me with the landlord's expenses as well, but because I have a good rapport with the landlord for 21 years, he decided to release me from the lease because Nick Curran just took off. And the lease was by another company of mine, subleasing to Flitner and Company. So basically it was a trespass by the legal board into the premises because Advantage Legal Proprietary Limited is the lessee, subletting to Flitner and Company. So there's an issue there from a police perspective of coming in to premises like that, which has never been explored. And to this date, I don't know what they have sold the business for, what she has profited on wills and probate at Lillian Di Maria and Associate, but they have put a really nice blurb on their website saying that they're very happy that they've gotten their practice larger, enlarged their practice with the legal board blatantly thieving without any public knowledge or anything out there, my practice.
So they wouldn't sell it to Sion Walters,
Nope.
but they were happy to sell it to another person.
Mm-hmm.
Were you consulted at all, or
No. I only saw documentation redacted who that sold it to until I saw on Lillian Di Maria.
So they didn't even tell you
website.
the name of the person they were selling.
No.
And
But
what
to
was
this day, Lillian Di Maria and Associates and Doreen have a big write-up on their front page that they've taken over Flitner and Company.
So on what basis did they withhold that information from you?
They just did. They just sent redacted documentation to the liquidator and to my lawyer.
Okay, and you were charged $200,000, or your
There is
firm
200
was invoiced
Yes.
$200,000.
They also wrote to me in November last year, the manager of external administration, asking me for my personal financials now to reimburse the public purpose fund of 3.2 billion at the moment, with me personally after having stolen my business for what they had paid Nick Curran on 200,000 plus.
But the practice was run by your company.
That's correct, and also Nick Curran decided to charge the public purpose fund willy-nilly without care or concern. So the 8 months was extended to 12 months when I appointed the liquidator. So they even extended his appointment because the liquidator was going to step in when his appointment ended. So it became 12 months till October last year, and that's why the computers were only returned in November
So
2024.
what did he charge the $200,000 for?
Well, he charged for himself. The original appointment said that his charges at $550, I recall, per hour. I never saw a cost agreement they had with him, the legal board, and Nick Curran at Thompson Gear, the partner at Thompson Gear. He charged then for his senior associates, paralegals, and receptionists on the accounts.
And
I just charged willy-nilly and didn't run the files. I had complaints. To this day, files weren't run, files disappeared, wills and probate disappeared. It's just, and these people have never ever found their wills. They've moved out of the safe. They're all accounted for when I left. Things disappeared in the practice. So after 6 months, I was going in there and just cleaning up furniture because they'd even taken financial records. They basically just helped themselves in the practice.
So the legislation clarifies that the appointment of the manager, as we've discussed earlier, is to effectively
Manage
look
the
after
practice.
the interests of the clients,
Mhm.
while the solicitor in charge of the practice is not capable of performing their duties or was otherwise incapable of discharging their duties. So you say that they didn't actually represent any of your clients or the firm's clients.
That's factually correct, yes.
So what did he charge the $200,000 for?
Don't know. I even had to contact him to tell him that I wanted my personal wills out of the safe, my son's surrogacy consent orders, and they didn't volunteer any documents that they had of mine to send to me. So when I asked for it, I've just received one registered mail envelope. Also, they didn't forward mail on to me that they were receiving in the post office box. Nor emails. Straight away when he took over, he cut off my access to my personal emails at thomas@flitnerlaw.com.au. So I was just cut off straight away. They rang up my service provider, said that they're the law unto themselves, that he's not allowed to speak to me with my website, and the other fellow at website Wise, he was and another guy that was having the hard drive of all my emails for paralegal and everything. They just confiscated, locked me out, got all the passwords. They even went into my private iCloud drive and were going trawling through that to find anything. And I said, you have no right to this. They were just going through everything to find things out on me.
And when they couldn't, then
This is factually correct. And I've written to Nick Curran and said, you're not allowed to do this.
okay.
And he just continued on.
And they waited until they had exhausted all of those options before they ultimately charged you with something that they had not done for 5.5 years.
That's correct.
Okay.
To justify why they had taking my business, or try to justify that
Because otherwise there's no other
basis, and I would be suing them now.
Okay.